3, 2, 1, start. A perusal of the order of punishment issued by the respondent number 3 reveals that Mahat Barua and the petitioner were tried jointly by SSFC on the basis of the ROE and that both of them were issued the punishment of dismissal from service. Stop para. It is well settled that the power of judicial review available to the High Court under the Constitution takes in its stride the domestic inquiry as well, and it can interfere with the conclusion reached therein if there is no evidence to support the findings or the findings recorded were such as could not have been reached by an ordinary prudent man or the findings were perverse or made at the dictate of the superior authority. Stop para. A perusal of the amendments made in paragraph 3.2 and in paragraph 4 of the affidavit in opposition would reveal that the respondents had clearly stated that the petitioner was given the responsibility to dominate area from BP number 279/8-S to BP number 279/19-S and that as such the petitioner could not have been charged of failure to stop cattle smuggling in the area from BP number 279/25-S to BP number 279/26-S. Stop para. The contention of the respondents to the effect that the petitioner pleaded guilty to the charge had not been established through appropriate materials and the respondents even did not respond to the petitioner's application under Rule 129 of the said rule. Stop. Furthermore, the respondents had even not complied with the provisions of Rule 142 of the said rules of 1969 and there had been no explanation and information of the general effect of the plea to the petitioner, and the petitioner was also not afforded any opportunity for preparing his defense as required under Rule 63, and decision was adopted in hottest and in blatant violation of the principles of natural justice. Stop para. The respondents through their affidavit in opposition had admitted that pertaining to the alleged charge, spot verification of the place of incident was done by Sri Brojesh Kumar in the capacity of Commandant 115 Battalion in BSF, and that on the basis of the said spot verification report, the charge of the petitioner was sought to be established and that the same officer, constituting SSFC, had issued the order of punishment and against the petitioner as would be explicit from the memorandum dated 9 November, 2006 at page 64 of the writ application. Stop. Such sequence of admitted facts establishes that there had been an unfair trial and blatant violation of principles of natural justice. Stop para. There is no answer on the part of the respondents as to why they had not considered the petitioner's claim in the light of the judgment delivered in the case of Roni Thomas Supra. Stop. The SSFC, by giving notice on 8 November, 2006, had fixed the hearing on 9 November, 2006 and had passed the order of punishment on 9 November, 2006, itself dismissing the petitioner from service without recording any reason whatsoever in support of the said decision. Stop. Such infirmity in the decision-making process renders the impugned order dated 9 November, 2006 to be unsustainable in law, and accordingly the same is set aside. Stop para. The memorandum dated 31st January, 2007, also does not disclose any reason towards communicate of the sentence, and in the backdrop of such records, it is explicit that the respondents were tentative and could not find any ground to substantiate the initial order of dismissal from service. Stop para. A perusal of the order of the respondent number 2 dated 22nd May, 2007 also does not reveal consideration of the petitioner's statutory petition dated 20th November, 2007, and the said respondent number 2 could not dislodge the specific and categoric contention of the petitioner that there was no nexus between the alleged misconduct and the petitioner, and that as such the said impugned order suffers from total non-application of mine and is a cryptic one, and accordingly the said impugned order is set aside and quashed. Stop para. The entire proceedings against the petitioner smacks of bias and closed mind, and all the authorities had been swayed by a preconceived notion that the petitioner had failed to stop cattle smuggling, being oblivious of the fact that the petitioner was commanded by his superior to dominate an area which was admittedly not the area in which the alleged smuggling had occasion. Stop para. For the reasons discussed above, the charge sheet dated 31st October, 2006 is issued by the respondent number 3. The order dated 9 November, 2006 passed by the Summary Security Force Court, order dated 22nd May, 2007 passed by the respondent number 2 are all quashed and set aside. Stop para. The respondents are accordingly directed to grant the admissible service benefits which had been denied to the petitioner pursuant to the order of punishment, within a period of 8 weeks from the date of communication of the order, as if no order of punishment was issued to the petitioner in relation to the disciplinary proceedings initiated pursuant to the charge sheet dated 31st October, 2006. Stop. The writ application is accordingly disposed of. Stop. In the fact of the present case, there will be no order as to cost. Stop. Urgent photostat certificate copy of this judgment, if applied for, be given to the parties, as expeditiously as possible, upon compliance with the necessary formalities in this regard. Stop.